Thank you. Thank you very much. I appreciate being invited to come and address you all. This is co-authored work, and what I've tried to do is to take a series of papers that I've written and synthesize it into a presentation that will give you a sort of general overview of our system and how our system works, and then focus on a very specific problem, which is how one of our most important jurisdictions, Delaware, has dealt with some issues relating to litigation costs. Now, the danger in presenting a paper like this is that the details are mind-numbingly boring to people that don't get involved in the system. And so the analogy I like to give is what we call, it's an American expression, a lot of this is inside baseball. So if you don't remember anything about this talk ever again, remember that expression, inside baseball. So how many of the Indians in the room even know what baseball is? All right, so you have some basic familiarity with the idea. All right, so inside baseball is when you get very caught up in the details of how the game works, like who the best hitters are and who the best pitchers are and what the right play is at the various times in the match. So you can maybe an analogy would be inside cricket, right? That's the danger of this paper. So I'm going to start at a very high level and hopefully be able to put it into some context so that some of this will make sense. So first, just a very basic theory. As you all know, we have a dispersed ownership system. In a dispersed ownership system, the big problem is management control of the company. Since there's no close monitor as there is in, say, a controlling shareholder system like in India's case, the problem is management has excessive power and management can engage in activities which benefit it at the expense of the shareholders. So there are a variety of different techniques that shareholders use to try and curb management opportunism. And basically they break out into three categories, voting, selling, and suing. All right, so we're going to talk about suing. And the idea here is that shareholders can use litigation as a mechanism to curb management opportunistic conduct. Okay, so in any system, there are two types of enforcement using the litigation mechanism. There's public enforcement, i.e. government enforcement, and private enforcement. So my understanding is India has a fairly robust public enforcement program. We also have a fairly robust public enforcement program. So we have an agency called the SEC that is empowered to enforce the federal securities laws. And they have an enforcement division. That enforcement division, in conjunction with the Department of Justice, brings many enforcement actions, both civil and criminal enforcement actions. And the question is that enough? Now, many people would argue that is enough. In our system, though, we have a fairly robust private enforcement mechanisms as well. And there are really four kinds of lawsuits that are brought. There are private securities fraud class actions. I'll discuss those more in a minute, but there are roughly about 200 to 230 private securities enforcement actions brought every year. There are state law acquisition-oriented, i.e. mergers and acquisitions cases. And what we'll see is there are about 100 of those a year. And then there are derivative suits. Derivative suits are suits that are brought by a shareholder on behalf of the company. They'll be a little less important in the context of this particular conversation, but they can be brought either in state court or in federal court. Okay, so this diagram shows you essentially the level of complaints that are filed in private securities litigation on an annual basis for an extended period of years from 2004 to 2018. And really, what this paper is about is this. What happened? You have this relatively constant level of enforcement, private enforcement in the federal court, and then all of a sudden you have a big blip at the end. Right, and what we're going to see is that big blip is a shift of litigation out of state court into federal court as a result of actions that one of our most prominent corporate law states, Delaware, took to try and curb what it perceived to be as frivolous shareholder litigation. Now, just to put this in a little context, other countries do in fact have securities fraud, private securities fraud class actions. This is a fairly comprehensive list of those that do. As you can see, there are a number of prominent jurisdictions. So you see Australia, for example, is one of the most progressive or perhaps regressive, depending on one's perspective, in allowing private securities class actions. And if you look at how these cases come out, there are really two kinds of outcomes. One is the case is dismissed by the court or dropped by the plaintiff because they are unsuccessful, or the alternative outcome is a settlement. And when the case settles, that means that the defendant has agreed to pay a certain amount of money, sometimes a very large amount of money, sometimes literally billions of dollars, in exchange for the case being dismissed by the plaintiff. Those billions of dollars show up in these numbers at the top of the table here. So you can see if we look at private securities class actions, and this is not only U.S., federal, state, SEC, but also non-U.S., which are a relatively small number, but still significant, $11.7 billion in 2018. So we're talking about significant amounts of money. And importantly for my story is that those significant amounts of money also generate very large attorney's fees for the lawyers that are bringing those cases. So 10 to 20%, sometimes perhaps even a little bit more, of that $11.7 billion goes to the lawyers that are bringing the cases on behalf of the shareholders. Okay, so there are benefits to shareholders. These dollar numbers are significant. There are benefits to shareholders from these cases, but there are also costs. And the costs are not only the attorney's fees, but that are paid out to the private lawyers in the successful cases, but also the costs that are incurred by the company in defending these cases, both in successful cases and in unsuccessful cases. So as a result, there have been a number of attempts to dampen down those costs, to reform the system in ways which make it less likely that we'll see frivolous litigation and more likely that we'll see positive merits-based litigation. All right, and I'll just really briefly go through some of these. They're not central to the story, but I want you to get a sense of the fact that this is an ongoing process. So in 1995, Congress was concerned about these private securities litigation class actions, and they instituted some legislation which required, for example, a court to choose a lead plaintiff in every private securities class action. And the idea there was that this would be a large shareholder, someone with real skin in the game, so to speak, and that they would engage in monitoring of the attorneys that were bringing the case and ensure that the attorneys were taking actions in the best interests of the class. Right? And there were a variety of others which are less central to the story. We can talk about them more later if someone's interested. All right, so that was in federal court. Now, in state court, as I mentioned, we have these two kinds of class actions. We have the mergers and acquisitions class actions, which are what my paper is largely about. And then we have derivative lawsuits, as I mentioned earlier, that are brought on behalf of the company. And again, the concern there is while there were benefits, so I cited one important recent Delaware case in the mergers area where the plaintiff succeeded in obtaining a $2 billion judgment on behalf of the class. But then there were also significant costs that were incurred, which again led to efforts to reform the system. So derivative lawsuits have been around a little bit longer than these mergers and acquisitions lawsuits. There have been a number of attempts to try to strengthen the derivative lawsuit procedural mechanisms to winnow out the bad cases from the good cases. So for example, we have each party bears its own cost system in general. So if you bring a suit, you pay your own costs, but you don't pay the costs of the other side. So that's a little different from the Commonwealth rule, where the loser pays. But what in the 1940s, what they did was they said, okay, well, we're going to require the plaintiff to post bond. And this was an attempt to stop small shareholders that had really no stake in the litigation from bringing frivolous lawsuits. Okay, and again, there are a variety of other mechanisms that were implemented, all with as an effort to try and control frivolous litigation. Okay, so that brings us up to what this particular paper is about, which is mergers and acquisitions litigation. Okay, and the basic claim here that plaintiffs bring is that the company directors sold the company, but they sold it for too little money. Now, either they sold it for too little money because they were careless and uninformed and they went to market without really understanding the value of the company, or they sold it for too little because they had some kind of conflict of interest. Now, Delaware, being our most important corporate state, tends to be the leader in this type of litigation. And it's the leader in this type of litigation for a variety of reasons. Some are substantive, some are procedural. The big procedural reason is that we have something called the Internal Affairs Doctrine, which says if you sue a corporation that is incorporated in a particular state, for example, Delaware, then the law that applies to your claim is the law of the state of incorporation. So if I'm suing a Delaware corporation claiming its director sold the company for too little, then Delaware law is going to apply to my claim, even if that corporation is not based physically in Delaware. All right, so the Internal Affairs Doctrine is very powerful for purposes of this particular paper, because it means that a lot of the litigation involving mergers and acquisitions is brought in the state of Delaware's state courts. But importantly also is that there are other options. You can file in a headquarters state of that particular corporation, right? So in my example, the company is incorporated in Delaware, but it's actually headquartered, for example, in New York. You could bring your case in New York State Court if you wish to do so. Or you can also file in federal court, either by bringing your claim as a federal law claim. There were inadequate disclosures about the sale, for example, that can be stylized as a federal claim, or because of what we call diversity jurisdiction, which is to say that you are a citizen of a different state than the corporation, and therefore you're entitled to bring your claim in federal court. All right, now from the plaintiff's lawyer's perspective, you choose which venue you file your case in. Right, so you really have three choices: Delaware, headquarters state, or federal court. And you're going to choose which jurisdiction you file in based on the jurisdiction that's most favorable to your claims. All right, so this is the kind of the key point of the paper. When you close down one avenue, when you squeeze, you know how you squeeze on a balloon, You squeeze on a balloon and the air moves to a different part of the balloon. So you squeeze over here and this part gets big, or you squeeze over here and that part gets big. That's what's going on in this paper. Right? Delaware squeezed, and all the cases went out of Delaware to other jurisdictions. So we haven't even gotten to the good part, and I'm already down to 5 minutes. I knew that was going to happen. Right? But just remember inside baseball. All right, so now becomes the inside baseball part. All right, so this is an interesting little diagram here. This shows what happened to merger litigation in the 2000s. All right, and this blue line here is the number of deals that were consummated, deals of more than $100 billion, $100 million. This orange line here is the number of cases that were filed. And what you see is that line basically from about 2009 on roughly parallels the line of the number of deals. In other words, basically every deal, this is the gray line, this is the percentage of deals, it's bumping along 30, 40%, and then boom, it goes up to almost 100%. All right, and this is the problem, right? Merger litigation exploded. It went from being common but not too frequent to being ubiquitous. Every case, every deal had a lawsuit filed, and obviously not every lawsuit was a valid claim. So there are a lot of frivolous claims being brought, and the reason is that, well, one theory is that what happened was that in federal court, where those class actions were being brought, those class actions became much more expensive to file after the litigation reforms in 1995. Now, from a plaintiff's law firm's perspective, that meant that they started to look for other venues. So they shifted out of federal court into state court, and this form of merger litigation suddenly became much more common. Okay, so this is the problem Delaware faces. All of a sudden, we have way too many of these cases. What are we going to do about it? All right? So Act 1, and this is getting down into the weeds, so I'm not going to spend a lot of time on it. But Act 1 is they allowed corporations to amend their corporate bylaws to require shareholders that were bringing state law claims to bring those claims in the Delaware court. All right, so now we're funneling the cases out of the state headquarters into Delaware. And we can't do that to the federal cases, but we can do that for the state cases. Act 2 is now Delaware has control of the state law cases. And so it begins to crack down on these, what it perceives to be frivolous lawsuits. And one of the ways that it does that is it says if you are bringing these cases and your claim is essentially the company didn't tell the shareholders everything they needed to know, that's called a disclosure case. Those disclosure cases settled very cheaply, and basically the trade was we'll give the plaintiff's attorneys some money and we'll give the shareholders of the company some additional disclosures, and in exchange they'll drop the case. And so that was Act 2. These disclosure-only cases suddenly became a lot harder to bring because the Delaware courts said, we won't approve settlements in those cases. All right, so Delaware becomes harder, and then Act 3 is we change the substantive law. All right, now I have 2 minutes to get through something like 15 slides. So this is going to be, I'm just going to cut to the chase. How about that? I'll go right to the... All of this leads to a change in filing patterns, right? So the changes in Delaware law all lead lawyers to start to look elsewhere. Where else can we bring our cases? And the answer is, well, we're going to stop bringing them in Delaware, we're going to stop bringing them in Delaware. So if you look at the statistics here, these are the percentage of M&A cases that are brought in Delaware. And you see it's 50%, 50%, 60%. Now we have these new rules going into effect, 34%, and by 2017, 9%. All right, so the rules worked, right? The rules worked. Nobody files these cases in Delaware, but the rules didn't really work from the company's perspective, because what happened was, if you look over here in the federal court, well, 20%, 30%, 15%, 87%. Right now, those cases all out-migrated into the federal court. All right, now a couple other things happened, and then I'll stop, and so Pradeep doesn't yell at me. Settlement rates, the rate at which these frivolous, disclosure-only cases, those settlement rates dropped substantially, and the number of cases that got dismissed rose significantly, from 38% to 89%. So the Delaware cases that were filed were largely dismissed. Attorneys' fees, the fees that attorneys make on these cases, they also dropped substantially, so that they went from about $450,000, $435,000, to less than $300,000 in the cases that actually settled. So even if you were successful as an attorney in bringing one of these cases, you made a lot less money in doing so. All right, so everything out-migrates to federal district court, and perhaps tonight our esteemed judge will talk a little bit about how the federal courts are dealing with this issue. But so what's the bottom line here? And this is my last slide. What's the bottom line here? Well, did we go too far? Right? We changed all these rules. We got rid of all these cases. But does that mean that the problem went away? Right? I mean, there was a problem. Right? The problem is sometimes directors have conflicts of interest, or directors are uninformed, and they sell the company for too little money. Now those claims will no longer be heard by the Delaware courts, and the question that's left is, will they be heard somewhere? Will the federal courts hear them, or will the federal courts take the same approach that Delaware took and say, there's too many frivolous cases here, we've got to do something to get rid of them, we're simply just not going to hear them. Okay, so I'll stop there and let whoever's going to present the slides present them. Maybe I should present them, I don't know.
Thanks very much, Randall. The discussion slides are by Shubho Roy, but he'll be here only later. But the slides will be used by his friend Pratik Datta, and Pratik is expected to do a great job of it. He's been his childhood friend, so he completely understands what he's thinking.
Now that all of you are aware of my being parachuted into this position, so I'll be very brief, and I'll use one point from the slide and one point just to relate it to what's happening to India. So one issue I think that Shubho mentions in his slide, and I mean I can just discuss this, is, are we certain that no rules change that increased in the federal rules that might have triggered the increase of caseload in the federal courts? So I'm not sure if your paper addresses that point, but that would be probably something that would be interesting to look at if all the other conditions remain the same, and if there has been any change in the rules that might also explain the parallel explosion in the federal courts caseload. As far as contextualizing this to the Indian context is concerned, what I find interesting is you are saying essentially that there are different forums for the same dispute, and it is perfectly fine to do forum shopping. In India, the concern seems to be exactly the opposite, where it is assumed that forum shopping is bad, and therefore you create a legal monopoly for a particular court in one type of a dispute. And this is a bit like regulatory competition, where if you have multiple forums, probably you will have more people thinking about how to reduce frivolous caseloads and therefore more experiments in terms of new rules. Whereas in India, probably that's a takeaway for us, because this just say NCLT for all bankruptcy disputes. So even if the rules are bad, there's no alternative forum that competes with NCLT and shows them that, if you can change this rule, you can reduce frivolous litigation. So I'm not sure if there's some kind of studies on this aspect, because I found this very interesting, because we generally tend to assume that forum shopping is bad, and therefore we create a monopoly of a tribunal or a court on a particular dispute. So this entire study would not be possible in India, because you would not have this rich data set. Neither would you have the possibility of this experimenting with new rules, that you tweak a rule and that reduces your frivolous litigation in one forum. So I think that's the main points that I have. I mean, I'm happy to discuss this once I have read your entire paper. So without that, I don't want to make any comments. But I think it would be useful if we could discuss this from a bit of the India perspective, because that's something very interesting for the Indian audience. Thank you.
Thanks, Prateek. I had allowed Randall extra 7 minutes, so therefore, I kind of anticipated a shorter discussion.
Okay. Hi. So one of my observations was that I think you presume that all cases filed in Delaware can be styled as federal cases. So I'm finding it a bit hard to understand and sort of attribute the correlation between the drop in Delaware cases versus the increase in federal cases only to, I think it kind of borders on Shubho's point about whether it's a change of rules, or it could also just be an increase in directors contravening federal rules, for instance, even if it's not an actual change in rules.
So maybe I could
collect
just
all the questions and then.
Okay.
Yeah.
Okay.
So it's interesting, the chart you presented where you show in 2009 the increase in litigation. The question that arises is all increase in litigation frivolous? So there seems to be this quick jump, leap of faith, saying that very high, for example, 100% litigation certainly indicates that a large part of it may be frivolous. What would be nice to see is some data showing the outcomes of these litigations. So how many got thrown out as frivolous versus how many were upheld? Because in the end, you do make this you do raise this question on, did Delaware actually lose out the genuine cases, and by changing rules which may have moved them away to federal court. So that would be really nice to look at.
Yes, Judge.
One of the points made was that the PSLRA, the Private Securities Litigation Reform Act of '95, may have caused the increase in Delaware merger lawsuits, but that chart that was just referred to shows that increase occurring in roughly '09, which seems like an awful long lag time. Yeah. And I wonder whether you explored other possibilities for that increase, like market volatility and uncertainty in the aftermath of the '08 crash, or whether there was some other thing that could explain the leap at that point in time.
Any other questions? Yes, Yesha?
Just a quick point. I was also wondering whether other jurisdictions have made it easier, for example, Nevada, to try and capture some business that is being lost in Delaware. So whether or not there's interstate competition as well as between state and federal competition.
Any other questions? Okay, Randall.
So there was no change in the federal rules in the relevant time period towards the end of the study. But claims that are brought in state court for breach of fiduciary duties can be brought in federal court as failure to disclose claims. So pretty much any claim that you stylize as a mergers claim can be brought in federal court as a disclosure claim. So there is a high degree of substitutability. There are some procedural differences which explain why those cases were brought in Delaware court initially, but that doesn't bar people from changing their minds and bringing them in federal court instead. On the forum shopping issue, yeah, I mean, you can argue that it leads to competition between jurisdictions, and that competition is a positive thing, which results in benefits. You can argue that it leads to a race to the bottom, and that therefore the plaintiffs just move to the worst jurisdiction possible. That's been argued both ways. It would be interesting to try to do a comparative study between a system like India, where you have a single court, versus a system like ours, where you have multiple options. Would be a very interesting study if you could figure out how to control for the other differences that are related to that. Now, somebody asked for data on outcomes. Sorry, it'll take a minute to get there. I kind of skipped over that. That's the big payoff of the paper, I think, that we have a lot of data on outcomes. So basically what we did was we hand collected all the M&A deal cases for the entire period from 2003 to 2017. We're working on a follow-up paper where we have the full data set extended out to 2017 and 2018 to try and look at this issue of what's happening to these cases in federal court. You know, who's bringing them and how are they being resolved? But in terms of the resolution of the cases that are filed, here's litigation outcomes, if that's what you're interested in, dismissal rates, settlement rates, and then fees and size of settlements. So I think there's a lot of outcome data. I'm not exactly sure what you'd be interested in knowing about. And then as to Judge Jordan's point, that's an excellent point. The financial crisis clearly did have an impact, but there was no real change in the legal rules at that time. There was a change in plaintiffs' law firm behavior. So I'm not sure exactly how to explain that other than the way I tried to explain it earlier, that you have a closing out of certain law firms that led them to look to other jurisdictions as a way of trying to maximize their particular firm revenues. The story that I heard was that there was one lawyer in particular who just decided to file cases against everybody, and when it turned out it worked, then there were some copycats. So I don't know if that story is true or not, but that's the best I can do for an explanation. Did I leave anything out?
Can I ask a clarification follow-up question, Randall, which is,
Yeah.
you mentioned about the substitutability between the federal and the Delaware cases.
Yeah.
And it's under disclosure, failure to disclose, that you go to the federal court. Is there a difference in the punitive action which can be faced by the defendant in the case, and is there a difference in the level of compensations that would potentially be available? And related to sort of Yesha's point about substitutability between states, I'm just thinking aloud here. To my mind, a lot of the decision making in all these courts depends to a large extent also on the composition of the courts. And the composition of the courts is very is conditional to an extent on whether they were nominated by Democrats or Republicans and things. So,
Yeah.
have there been any studies which would kind of highlight the fact that that competition between states would be time varying based on what the composition of the court is, and you have a very rich data set. It can potentially be exploited for such a study if it's not there.
Okay, so your first question was, is there a difference effectively in the power of the court in what it does in resolving the case between state and federal. Both courts have the same set of general tools. In federal court, the PSLRA, the Private Securities Litigation Reform Act, applies, so you have to comply with the procedural rules that apply in that for that particular jurisdiction. But in general, you can bring the same case in either court, and while it may matter who your judge is, it probably doesn't matter so much whether it's federal versus state. In terms of the competition between the states, this is a huge issue, and we do address it in the paper. I kind of skipped over it. But the question that Delaware faces is it really shot itself in the foot. If you think about how laws are created, there are various theories about how law gets formulated, but one powerful theory is what's called interest group theory, where if you think about who's responsible for Delaware law, in large part is the Delaware legislature, but also the Delaware bar. And so if I'm a lawyer in the Delaware bar and suddenly all this litigation disappears, that's going to adversely affect my income. So one could argue that the Delaware bar made a big mistake in the way it approached these cases, and that they'll back off from that and allow some of these cases to come back in. And it'll be interesting to see if that does or doesn't happen. One of the purposes of doing the follow-up paper is to just get a better sense of what is going on after this big shift occurred. And whether it's moving to other states, like Nevada, for example, is often mentioned as the principal competitor among the states to Delaware, or whether it's all moving to federal court.
Thanks very much, Randall.